I will go for the introduction of our presentation, and I will explain about SOCSO and its principle. SOCSO, or also known as Social Organization Security, was established in 1971 under the Ministry of Human Resources. It is to implement and administer the Social Security scheme under the Employees Social Security Act 1969, namely Employment Injury Scheme and also an Invalidity Scheme, and it was evolved as a statutory body in 1st July 1985, and beginning in 1st January 1962, SOCSO has implemented its own system. Through Act and regulation, SOCSO is able to provide pre-medical treatment facility for physical or vocational rehabilitation and financial assistance to employees if they have lost their abilities due to accidents or diseases that have reduced their abilities to work or rendered them incapacitated. In fulfilling those responsibilities, SOCSO has three core principles. The first one is a solidarity fund. Solidarity is the main value of social protection. In practice, it is a series of mechanisms for redistribution of income towards people who are disabled or invalid or families with dependent children. Employees share the same level of exposure and risk sharing regardless of industry in which they operate in. Sharing of risks in this context means the understanding that all contributors agreed and united in allowing SOCSO to use the Solidarity Fund to pay benefits to employees who suffer disability or invalidity and pension to dependents in the case of death. The second principle of SOCSO is replacement of income. This principle applies when determining the amount of benefits of payment. It is related to the amount of contribution paid based on employee's salary. This concept is to ensure that employees do not feel financially affected if they have disabilities or invalidity. In the case of death of an insured person, replacement of income is provided to dependents through monthly pension. And the last but not least, the core principle of SOCSO is the principle of equality. The fundamental basis of principles within the Act and regulation itself, by virtue of the concept of social justice, the coverage of the scope must encompass all employees and employers registered to SOCSO. Through this concept, prevention accidents with objective of zero accidents and a foster culture of healthy lifestyle should be implemented, because the redefinition of social security is keeping employees in the workforce until retirement.
Next, I will proceed with the trend of social security organization, the global change of social security. The global change of social security starts from the traditional approach of social security, which is compensation oriented. The example that can be taken is by paying the employee to stay off work. This can be related to International Labour Organization Convention 159 and Recommendation 169, 1998. The recommendation provides that where possible and appropriate, Social Security scheme should provide or contribute to the organization, development and financing of training, placement and employment, including sheltered employment program and vocational rehabilitation service for disabled persons, including rehabilitation counseling.
There are lots of issues arise in the line of SOCSO nowadays. The first issue I would like to mention is the issue involving the employers with SOCSO, which the issue of employers who fail to register and contribute their employees in SOCSO. But before we go any further, let us go deeper into the two terms of employers, which are principal employer and immediate employer. Principal employer is the owner of an industry or the person with whom an employee has entered into contract of service or apprenticeship. Includes among others manager, agent or person responsible for the payment of salary or wages to employee, and also the occupier of factory. While immediate employer is a person who undertaken the work of the trade, business or profession of the principal employer under the principal employer's supervision or on the principal employer's premises. This includes a person who lets on hire his employee temporarily to the principal employer. Now, let us look into the provisions stated by the Employees Social Security Act 1969 about employers. In the Act, the principal and immediate employer who employs one or more employees is required to register and contribute monthly to SOCSO for all of their employees. The principal employer is also liable to ensure all employees employed by the immediate employer have been registered and their contribution have been paid. Unfortunately, some of them are not following this rule. This can be proved by some of the cases published in the local papers. For example, Utusan Malaysia reported that as much as 108 employers failed to contribute to SOCSO for the employees in Pulau Pinang in the year of 2012. For me, that's a big number. Well, other than that, there is a report by Cosmo on 2014 which stated that 313 cases of employers in Malaysia failed to register and contribute SOCSO for their employees in 2013. What a shocking numbers for me. The point is, this issue is one of the big issues arises in the line of work of SOCSO currently. To deal with this, SOCSO has came up with a brilliant idea called Ops Kesan. Ops Kesan is basically an operation to trace any employers who fail to register and contribute their employees to SOCSO. The operation began on 1 March 2011 all over Malaysia simultaneously, which later was conducted annually until now. The operation will succeed in many ways, as SOCSO managed to find and compound certain employees to who failed to fulfill the obligation from 2011 to 2014 all over Malaysia.
Another issue that arises regarding to SOCSO is the delay in lodging complete report on workplace accident by employers. Before we go further, what is meant by the workplace accident? Workplace accident is a discrete occurrence in the course of work which leads to physical and or mental harm. Employment injury usually related from the workplace accident. This issue is a serious concern for SOCSO as it will deny the rights that the employee should entitled to because of the irresponsible of the employer to lodging the report to SOCSO. As example, on 2012, 20 employers from the Cebu district have been compounded for failing to report accidents involving their employees to the SOCSO as this news is reported by The Star. Based on the issue, I recommend that SOCSO should impose stricter regulation to be followed by the employer on lodging the report on the workplace accident. Addition to my point, SOCSO also may send their officer to inspect the workplace where the accident occurred and directly collect the complete report of the accident. This may help to cope with this issue and will make the employer to become more responsible and alert to what happened in their workplace.
Last but not least, the issue number 3, which is effective compensation needed. There is a case where the workers are losing out on SOCSO claim because doctors do not link disease and health problem to the job. Sadly, it is not only doctors that let down workers. SOCSO can be equally guilty. There is the case where SOCSO Medical Board has approved the workers' benefit only to have it later rejected by SOCSO Medical Appellate Board. Does SOCSO not trust in own medical board? There are also workers who claim are rejected because they were filled more than 1 year after the accident. There are illiterate workers who are unaware of the SOCSO benefit available. By the time they find out from friend of friend, it is more than 12 months. Although SOCSO regulation allow it to extend the time limit for filing claims, it does not exercise it often enough. As a recommendation, employer must be mandated to provide a safe and healthy working environment. This include the use, handling, storing and transporting of chemical or machinery, and the education, training and supervision of workers on health and safety measures. Stiff penalties should be imposed on those employers who default. Next, the whole system of handling workers with occupational illness need to be reviewed. The SOCSO study has already found that many employers were reluctant to notify SOCSO of occupational diseases for fear of visit by authorities, closure of operation, stop work order and sealing of equipment. Employees themselves do not report such illness for the fear of dismissal of discrimination by employers. Panel doctors are expected to detect and report work-related diseases, but this system also has its drawback. Okay, furthermore, to be placed on a company panels, doctors may compete among themselves to reduce the cost of medical treatment. This low cost may compromise the quality of treatment. As an alternative to a panel made up of individual private clinics, SOCSO could fund occupational health unit in all government hospitals. Workers can access this unit if they are suffering from an occupation related disease and need treatment. SOCSO can claim be evaluated and processed using a standard system throughout the country. Okay, next, training for more doctors in the field of occupational disease also need to be expedited. Industrial health nurses could be stationed in the bigger organization or in an organization that carries out hazardous operation. This should be mandatory and strictly enforced. Some international companies keep record of their workers' health history and the risk that they have been exposed to during the course of the work. Such keeping of record would be made a legal requirement here in Malaysia.